Good morning, members of the House. This is a motion to amend House Rule 45.9A and B to modify the role of the House of Delegates in the law school accreditation process. The modified language of the rule is in the reports in your book and is also on the screen. This is a change that's necessitated by the rules of the regulations of the Department of Education, which recognizes the Council of the Section as the official accrediting body for law schools offering a first degree in law in the United States since 1952. Prior to 1999, the House had an actual role in the accrediting decisions. It could approve the recommendation or disapprove the recommendation of the Council. In 1998, the Department of Education determined that the Council's process was not in compliance with the Department of Education's requirement that the decision-making body of an accrediting agency must be separate and independent of any related trade association. At that time, the Board of Governors created a working group which proposed and the House approved the process that has been in place since that time. Under the current process, an action to deny provisional or full accreditation or to withdraw accreditation from a law school can be appealed to the House of Delegates. The House of Delegates cannot change that decision, but if it does not agree with the decision of the Council, it can refer the matter back to the Council with specific recommendations for further consideration by the Council. A matter can be referred back twice if it deals with the approval of or denial of approval of a provisional or full accreditation, and it can be referred back once if it's related to the withdrawal of accreditation. In October of 2009, the Department of Education promulgated a new set of regulations which became effective on July 1 of this year. Under these new regulations, it requires that the body to which an appeal may be taken from adverse decisions of an accrediting body must have and use authority to make decisions to affirm, amend, or reverse actions of the original decision-making body. The appeals body must, in effect, be more than an advisory action. This change in the DOE regulation also requires that an appeals body include, within the scope of the accrediting agency's DOE recognition, and must comply with the separate and independent requirements. It must comply with the requirement that 1/7 of the members be public members, and it must have adopted a conflict of interest policy. Such a regulation could not, we believe, be successfully accommodated by the House as it currently exists. At the request of the section, the American Bar Association's General Counsel sent a letter to the Department of Education seeking to confirm that our existing procedures complied with the new regulations. On March the 1st, the ABA's General Counsel received a letter from the Department of Education saying that our procedures did not comply. The section also sought advice from its outside general counsel, who has represented the agency before. In the conclusion of the opinion of the outside counsel, it's been determined, in essence, that the House cannot continue to serve as an appellate body for the accreditation process. In anticipation of this amendment to Rule 45-9, the section last week adopted new appeal procedures for implementation once this rule is modified. Action by this body is really urgently needed so that the section can remain in compliance with its accrediting body, the Department of Education. The section will be filing its application for re-recognition this fall, and we urge you to take this action to bring us in compliance with the rules of the Department of Education. Thank you very much.